So we're going to start off here on page 8, and this is just a continuation of if you have a second deed out, we would need that information and what is owed on that, and all the information that you have on your property. If you have any other deeds of trust, second deeds, liens, second mortgages, etc., this is what we would need in this section. So we're in 2. The seller is current on all payments for the loan identified to number items 1, 2, and 3 above, except as specified in 7 below. The seller is not in default or in any loan identified in number items 1, 2, and 3 above, and has not received any notices from the holder of any loan identified in numbers items 1, 2, and 3 above, or from any other lien holder of any kind regarding a default under the loan, threatened foreclosure, notice of foreclosure, or the filing of foreclosure except specified in 7 below. And then we're going to go through 4, 5, and 6 to 7. Okay, there are not any liens secured against the property for federal, state, or local income taxes unpaid, real property taxes unpaid, condominium, a homeowners association fees, mechanic, laborers, or material men's liens, or other liens affecting the property, and the seller has no knowledge of any matter that might result in a lien affecting the property except as specified in 7 below. And there, number 5 is that there are not any judgments against the sellers affecting the property, and the seller has no knowledge of any matter that might result in a judgment that may potentially affect the property except as specified in 7 below. Number 6, there are not any Uniform Commercial Code UCC fixture filings against the property, and seller has no knowledge of any matter that might result in a UCC fixture filing affecting the property except as specified in 7 below. And the last one is number 7. Specify any information including approximate balances required by the seller, representations 2 through 6 above. So this is where we're going to specify anything out there that you know that may be an issue with you selling this home. This note is outstanding liens may affect the seller's net proceed. So just know that if once we get your house listed, or once we're doing the paperwork to list your home, we're going to do a estimated seller net sheet for you. So let's just say you were supposed to receive $20,000 back. But when we start going through this process and the attorneys have pulled the title search, we have seen that there was a mechanic lien out on the property that you didn't know anything about, and it's $10,000. Well, that $10,000 has to be paid at closing, and that comes out of your proceeds. So now you're only going to be netted $10,000. So that's what it's saying. Any liens that does come up, whether you know about it or not, it's going to come from your net proceeds. Okay, and this is leases. The property is or is not subject to any lease. And if applicable, the seller agrees to promptly provide the firm of a copy of such lease. So, any lease agreements that is out there, if this property is being leased, it has a renter in it, then we need all of the terms and conditions of this lease. And then number 2, if the property is managed or someone other than the seller manages this property. So we would need the name, all the contact information of the property management team. If you're renting out this home and you're not managing it yourself, you do probably have a property management team. So we just need all of their information. And the seller authorizes any such manager to release any and disclose to the firm any relevant information about any leases, and to cooperate with the firm in the sale of the property. So again, that just goes hand in hand. If it is a property management, you need to get in contact with them and let them know that Moving Forward Real Estate will be selling your home, that they can release any information that's needed that I need to me. An FHA appraisal has or has not been performed on the property within 4 months prior to the effective date. If applicable, the seller agrees to promptly provide the firm a copy of any such appraisal if available. So that's pretty much self-explanatory. If you've gotten your home appraised within the last 4 months, then we would need that appraisal. Okay, note, any such appraisal may or may not be binding on a buyer who intends to obtain the FHA financing. So it's just saying that the appraisal that you got, it may not be binding to them because, of course, anytime the buyer purchase a home, they're going to require their own appraisal. But so this is just saying, just know that it may or may not be binding to them when using FHA financing. Okay, we're at O, special assessments. There are no special assessments as defined in the sample contract form provided to the sellers regarding the property that have been approved or under consideration, except as follows. And then you need to insert or the identification of the such assessments, if any. So if there's any assessments on the property that you know of, approved or confirmed, we need to know that. And this is getting down to the fuel tanks and all the information on the fuel tank. If you know you have a fuel tank, we need all of that information. Anything that you do know about it, if it's leased, if it's owned, we need to know that. Okay, we're at the top of page 9, just a continuation of the tank, the fuel tank. And we are here where it says tanks included in the sale. Any tanks described above that is owned by the seller shall be included in the sale as part of this purchase free of lien, unless excluded in paragraph 3 above. Number 3, this about the fuel. The seller may use the fuel in the tank described above through settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as of settlement shall be included in the sale as part of the purchase price, free of any lien. So it's just stating here, if you have fuel in your in the fuel tank, you are able to use it until we close on the home. And once we close on the home, the fuel and the fuel tank is going to convey with the new owners, with the buyers, which will be the new owners. We have a note here. And the note states that the seller is advised to consult with the seller's fuel provider to discuss the manner in which any fuel tank will be refilled between the date of a contract on the property and closing of the property, including discontinuation of any periodic refilling. So you just need to get with them and just see how, if you needed some more fuel, if you could just get just enough to get you through closing, how they want to work that out. And then also to let them know that you will be selling this property and that they can discontinue any, like if you're on a monthly service or every other month or maybe once a year, twice a year, however, whatever system that you're on, you can let them know that they can discontinue that at that time at the date of closing. Okay, and this note says the seller's use of the fuel in any fuel tank is subject to the seller's obligation under paragraph 8C of the offer to purchase and contract form 2T to provide working existing utilities through the early of closing or possession by the buyer. So you just need to keep your utilities on is basically what they're saying. Any fuel in here, it just needs to be taken care of and maintained, so we can come in and do our inspections or whatever, keep everything on until we close. And I always have my sellers discontinue their services the day after closing, just in case we have something that goes on, and to make sure that it is on all utilities and everything is working and in working order. Definitely when the buyers do their walkthrough, their final walkthrough. And then now we're at Q. Off-site or separate septic lots, boat slips, garage, parking spaces, storage units. We need to address if the property will or will not include the following things. In governmental compliance, the seller warrants that the property is not in violation of any law, ordinance, permit, or governmental regulations, including but not limited to those relating to building, storm, water, impervious surface, environmental protection, and zoning, except for the following. So this is what we would need to list here if there is any such thing to be listed. If during the term of this agreement the seller becomes aware of any of the representations set forth in this paragraph 12 are incorrect or no longer accurate, seller shall promptly notify the firm and cooperate with firm in taking appropriate corrective action. So anything that we've stated in this agreement thus far, if by chance you find out that, oh, I do have a second mortgage, I forgot all about that or whatever, just go ahead and let me know so we can make the necessary corrective action. 13. The seller's duty. Seller agrees to cooperate with the firm in the marketing and sale of the property, including but not limited to the firm providing to the firm in a timely manner accurate information, including but not limited to the following: the Residential Property Owners Association disclosure statements, unless it's exempt, in the mineral oil and gas rights, unless it's exempt, in the lead-based paint addendum with respect to the residential dwelling built prior to 1978. So this is something that is a part of our listing package. And of course, we will give these items to you for you to fill out. You only will have this lead-based paint if your home was built prior to 1978, but we need to have the residential property disclosure and the mineral oil and gas rights before I, list this home, because the buyers need to receive it actually before they even submit an offer, so they can go through it and kind of do a little due diligence to see what's up with the property. And the thing about these two items, especially the residential property disclosure, I cannot help you or coach you in filling this out. This is all the information about your property, and it's about 33 or 35, something like that, questions that you'll just go in and just fill in the blank. If you have any question about what a particular question means, I can explain that to you. But for the most part, you have to fill out this without my coaching or leading in any kind of way. So that's all that is. And then we'll go ahead and upload that to the transaction desk in the MLS for the buyers. And we're here at a warning. The seller understands that if a lead-based paint disclosure is required but not given to buyer prior to the seller's acceptance of any offer, the buyer may not be obligated to purchase this property under federal law. So we just need to make sure that we get that to them ASAP, or they will not be required to move forward in the contract if we had gotten that far. They need to have that up front, definitely with the lead-based paint, if the home was built prior to 1978, so they can be aware of, what they're getting into, and just to make sure that everything has been taken care of regarding the lead-based paint or not. They just need to know either or. Okay, and B, making the property available for showings, including working existing utilities at reasonable times and upon reasonable notices. So you just need to make sure the utilities is on at all times, so your buyers can do a thorough investigation and inspections of the property. And C is providing firm as soon as reasonably possible after the execution of the agreement, copies of all following documents where relevant in the possession of the seller. Okay, we have 1, 2, 3, and 4. Okay, number 1, restrictive covenants affecting the property. We need that. Bylaws, articles, or incorporation rules and regulations and other governing documents of the owners association and or the subdivision. So we need all of those documents. If you are in a subdivision where there's HOA, we need those covenant rules and everything that you have on, about that. The owners association statements of accounts, master insurance policies, showing coverage provided, and deductible. So this is like if you were in a condo, we need to upfront be able to get a questionnaire signed by the HOA department, where it's going to give us all the information about the insurance, parking spaces, all of that good stuff about that particular condo. And on number 4, title insurance policies, attorneys' opinions on title surveys, covenant deeds, notes, and deeds of trust and easements relating to the property. So anything that you have on your property, again, definitely easements. We need to know and have that in hand so we can transfer that over to convey that over to the buyers, so they'll know, hey, this property has an easement. So they'll be well aware when they're sitting down at home one day and they see that truck drive on the side of their home. They know that this is an easement and they have to pass through their side of the home to get to their home. So we just want to make them aware of everything that has to do with this property so they can make a sound decision. The seller authorizes that any attorney presently or previously representing seller to release and disclose any title insurance policy and such attorney's files to firm. Number 2, the property's title insurer or its agent to release and disclose all materials in the property's title insurers or title insurer's agent file to the firm. And number 3, the owner's association manager or other authorized representatives to release any disclose under no obligation to inquire any of the information referenced in this paragraph C, or to verify the accuracy of any such information that may be provided to the firm. So we just need all that information, and for you to get with those necessary people, the HOA people, to know that maybe we'll be giving them a call so they can release the information to us that we need to make sure we have all documentation about this property, the HOAs, any attorneys, if there's any issues, we can talk to them. They will give us the information, anything that needs to be disclosed regarding any type of title issue that maybe once was, and now that it isn't, whatever's in the chain, we need to know so we can get this house listed and get it listed correctly, so we don't have nothing that comes back, in the middle of it or towards the end that will bring about any issues with us selling this property. Okay, and we have Section D, immediately referring to the firm all inquiries or offers it may receive regarding the property, showing the property only by appointment made by or through the firm, and conducting all negotiations through the firm. So if you're just in Walmart again and you run into your neighbors and they know that you're selling your home and someone wants information on that, try not to give them too much of information, refer them to us so we won't have a conflict. Maybe you'll say something that is different than when they talk to us, and there won't be any, issues. Just conduct everything and make every negotiation. Just let them know that yes, Michelle is handling it. They are, she's moving for real estate and they're listing our home. Let me give you her contact information, and that exhausts you from, doing our job basically. So here we are at the top of page 10. And it's E, executing and delivering at settlement a general warranty deed conveying fee simple marketable title to the property, including legal access to a public right of way, free of all encumbrances except ad valorem taxes for the current year, utility easements, right of ways, and unviolated restrictive covenants, if any, and those encumbrances that the buyers agree to assume in the sales contract. The seller represents that the seller has the right to convey the property and that there are currently no circumstances that will prohibit the seller from conveying fee marketable title as set forth in the preceding sentence, except as follows. We would put down here anything that you would know of, if anything is applicable to you conveying this home with free and clear, simple marketable titles. Means no liens. There's no There's no liens. There's nothing there that will hinder you from selling this property. This note says that if any sale of the property may be a short sale, consideration should be given to attaching the NCAR Form 104 as an addendum to this agreement. So if there is this home is going to be a short sale, then I would need to get with the lender and get the necessary addendum to attach it to this agreement, and so the sellers would know that the buyers would know that as well. F, providing firm in a timely manner any information necessary, including any information omitted under paragraph 12, to enable firm to prepare an estimate of seller's net proceeds at settlement. The seller acknowledges and understands that any such estimate is an approximation only, and that the seller should verify the accuracy of the calculation. So again, this is just an estimate. It's just an approximate number that we come up with the information that you give us. Now, provided some other things come up, some other items come up, some lien come up, of course that number is going to change, but we just need to know everything that you know so we can get as close to letting you know exactly what your net proceeds will be. And G, if required by the NCGS, timely designating a lien agent and providing firm as soon as reasonably possible a copy of the appointment of the lien agent. And we're on number 14. The home inspection. Seller is advised to obtain a home inspection for the purpose of evaluating the condition of the property or in order to enhance its marketability and to help reduce concerns of prospective buyers. So what number 14 is saying that, we're asking if you're going to get a home inspection prior to us listing the home or you are not. And if you are, we just need to know when did you get it done so we can put these days in here after the execution of the agreement. So we just need to know when you did it. You don't have to do it, but some people like to do it to kind of get ahead of the game. But again, you don't have to do that because I don't want you all spending money that you don't need to spend on a home. We do know big ticket items. So if you know that something is broken in your home, the HVAC is not working, or there's some shingles missing and there is a definite hole in the roof or something, you see some leaking, then, let's go ahead and be proactive about that. But I'm just talking about some other niceties inside, more cosmetic things. Let's not put too much money into that until the buyers, submit whatever they want to in the due diligence repair request. And that way we can go from there. Okay, the photographs and other materials the firm is specifically authorized to use for any purposes whatsoever, any and all photograph, drawings, videos, advertising, copy, or other information obtained by or provided by the firm's pursuant to this agreement, including but not limited to any information concerning the price and the terms of the sale of the property, the description of the property, and the length of the time the property is on the market, materials both before and after the sale, or in the event that there is not a sale, the direction of the firm or an agent of the firm, either during or after the terms of this agreement without the firm's written consent. If the seller provides any materials to firm, seller materials. Seller represents that the seller owns the seller materials or otherwise has the legal right to provide the seller's materials to the firm, and the seller grants to firm and any listing service in which firm or its agents participate a non-exclusive perpetual license to use the seller's materials, including the right to display, reproduce, distribute, or make derivatives works from the seller's material. The seller agrees to indemnify and hold the firm and its agents harmless from any and all claims resulting from the use of the seller's material under the terms of this license. Okay, number 16, additional terms and condition. The following additional terms and conditions shall be a part of this agreement. So any other additional terms that we want to add to it, this is where we will put this. And this section is talking about dual agency. This is 17. The seller understands that the potential for dual agency will arise if a buyer who has an agency relationship with the firm becomes interested in viewing the property. The firm may represent more than one party in the same transaction only with the knowledge and informed consent of all parties with whom firm acts. So it's just saying that you are in agreement or you understand what dual agency is, and dual agency is me representing you and me representing the buyer side. A is saying disclosure of information. In the event that the firm serves as a dual agent, the seller agrees that without permission from the party about whom the information pertains, firm shall not disclose to the other party the following information: that a party may agree to a price, term, or any condition or sale other than those offered. Number 2, that the motivation of a party for engaging in the transaction, unless disclosed, is otherwise required by statute or rule. And number 3, any information about a party which that party has identified as confidential, unless disclosure is otherwise required by the statute or rule. So again, dual agency can get pretty sticky. We're basically at that time facilitators. I cannot tell you any pertinent information about the buyers, and I can't tell the buyers any pertinent information about you, your motivations, and anything to sell, any reason to get them. Your motivation to sell. I can't tell you that the buyers, hey, they just, won the lottery. And so now you're going to hold out to get more money from them because you know that they have it. I can't share any of that information with either party. I got to kind of stay mutual in the situation and can't give either one advice on how to approach this situation when it comes down to the negotiation of certain things. I'm kind of just facilitating. I'm the middleman. In Section B, the firm's role as dual agent. If the firm serves as agent for both the seller and the buyer in a transaction involving the property, the firm shall make every reasonable effort to represent the seller and the buyer in a balanced and fair manner. The firm shall also make every reasonable effort to encourage and affect communication and negotiations between the seller and the buyer. Seller understands and acknowledges that prior to the time of dual agency occurs, the firm will act as the seller's exclusive agent. Number 2, in its separate representation of seller and buyer, the firm may obtain information which, if disclosed, could harm the bargaining position of the party providing such information to the firm. Number 3, the firm is required by law to disclose to the seller and buyer any known or reasonable ascertainable material facts. The seller agrees that the firm shall not be liable to the seller for disclosing material facts required by law to be disclosed, and refusing or failing to disclose other information the law does not require to be disclosed, which could harm or compromise one's party's bargaining position, but could benefit the other party. So again, it can get really sticky being a dual agent, but you have to understand, as the seller, I work for the buyer as well, so I have to give them all information, kind of just like in a regular, if there was another buyer's agent and I'm just working for you, I still have to let the other parties know of any material facts or anything that I need to know, regarding that they need to know regarding the party. I can't withhold anything about regarding the property. I can't withhold any information from them, and you won't. You won't put me in a position where I have to do that, because before When I was just representing you solely, there are things that I can withhold or not share or don't have to, as long as it's not a material fact, because I'm representing you and I'm trying to get you to get the most for your property. But now I'm in a situation where I'm looking out for both parties. So that's all that this is saying, that I need to disclose anything that could harm or compromise one's bargaining position. And initials are required here at the bottom of this page as well. So we're at C. Seller's role. Should the firm become a dual agent, the seller understands and acknowledges that the seller has the responsibility of making seller's own decision as to what terms are to be included in any purchase and sale agreement with a buyer, client, or firm. Number two, the seller is fully aware of and understands the implications and consequences of firms' dual agency role as expressed herein to provide balanced and fair representation of seller and buyer, and to encourage and effect communication between them rather than as an advocate or exclusive agent or representative. Number three, the seller has determined that the benefits of dual agency outweighs any disadvantages or adverse consequences. Number four, the seller may seek independent legal counsel to assist the seller with the negotiation and preparation of a purchase and sale agreement, or with any matter relating to the transaction, which is the subject matter of a purchase and sale agreement. So you're able to seek legal advice if you need to, because of course, I couldn't give you legal advice anyways, but seek legal advice as to, whether or not to enter into this agreement or, the dual agency. And even when it comes down to that, we are under a dual agency situation. You can seek advice to see, to advise you more on helping you to come up with whatever answers to the questions, or if you're in a situation where you need to figure out, because it's going to be your responsibility to make your own decision in this situation, you're able to, seek independent legal counsel on that to help you get through that particular portion if needed. And should the firm become a dual agent, the seller waives all claims, damages, losses, expenses, or liabilities other than for violation of the North Carolina real estate license law and intentional wrongful acts arising from firm's role as a dual agent. Sellers shall have a duty to protect seller's own interests and should read any purchase and sales agreement carefully to ensure that it accurately sets forth the terms which the seller wants to include in said agreement. So that is pretty self-explanatory. In this situation, you are waiving all claims and damages, losses, expenses, or liabilities, and other violations of the North Carolina Real Estate Commissions. You can't hold us responsible for anything other than things like that we do, that it will be a violation, with the North Carolina Real Estate Commission, any type of wrongful acts arising from the firm's role as a dual agent. You are withholding any type of liability to us, you're waiving those rights. You're waiving all claims to damages, losses, expenses, or liabilities, as long as we're staying in compliance with what we should do. Definitely representing who we are as realtors. You can't really, hold anything against us. So D is a designated dual agency, and this is another alternative with me just being your representing you and representing the buyer. In my firm, I can designate someone in my firm to be the buyer's agent as long as I have not shared with them anything about the transaction up to that point. Then that will be another way of doing it. So I can still represent you solely, but someone in my firm is going to take the buyer's side of it, but you still, have pretty much exclusive representation. This note states that an individual agent may not be designated to represent a party in a transaction if that agent has received confidential information concerning the other party in connection with the transaction. So, again, if I have shared with them any type of information regarding this property, how much it is, anything about the property, not so much how much it is, because they'll know that from just the listing agreement itself, but just any type of pertinent information that I've shared with them about my client. As long as they don't know that, they will be a great candidate. If they do, then I have to choose someone else. And this section is where we're going to check off. You're going to agree or not agree, you agree to the dual agency. The seller does or does not authorize the same individual agent to represent both the seller and the buyer in a transaction, or also initial here if the firm offers that designated dual agency and the seller authorizes that portion, then you can you can sign an initial here if you're okay with the designated dual agency, or you just want me to exclusively represent you. This is your desire, so you can initial here. So whichever one you initial is that's what we're going to adhere to. Termination, breach, mediation, attorney fees. So, a termination. Seller acknowledges and understands that this agreement constitutes a binding, exclusive contract between the seller and the firm for the entire term stated above. Seller withdraw from the fiduciary relationship existing between the seller and the firm prior to the expiration date of this agreement, or the seller execution of a listing agreement with another firm that becomes effective during the term of the agreement, would be a material breach. And this agreement, unless it has been terminated in writing by mutual consent of the seller and the firm, or for legal sufficient cause, and any subsequent sale of the property during the term may entitle firm to the fee described in paragraph 7. So again, it's saying that we are representing you. If for some reason you went off and you did you hired another company, we didn't know that, and now we're at the end, and somehow you have two listing exclusive right to sell listing agreements, because you did that without receiving a termination agreement from us, we are entitled to our commissions as well. B, breach. If the seller is in material breach of this agreement, firm will be entitled to pursue all remedies available to firm for such breach, including but not limited to recovery of the fee described in paragraph 7. This provision is in addition to the firm's right to the fee if the seller breaches this agreement after the fee has been earned in accordance with paragraph 7b. If the firm is in material breach of this agreement, the seller will be entitled to pursue all remedies available to the seller for such breach. Mediation. If a dispute arises out of or related to this agreement or the breach thereof, and if this dispute cannot be settled through negotiation, the parties agree first to try in good faith to settle this dispute by mediation before resorting to arbitration, litigation, or some other dispute resolution procedure. If the need for mediation arises, the parties will choose a mutual acceptable mediator and will share the cost of mediation equally. Okay, D, the attorney fees. If legal proceedings are brought by firm or seller against the other, the parties agree that a party shall be entitled to recover reasonable attorney fees. So if one of us have to take the other one to court, then the opposing party, the one that is taking the person to court, we are saying that we're wanting the other party to pay for the court costs, the court fees, reasonable attorney fees. Initials here. So we're at 19 with wire fraud. So we just need to be careful of that when you're making any wire transfers. If you needed to pay at closing, if you owed as a seller to closing and you needed to make wire transfer, we just need to make sure that you have the correct information from the institution, from the attorneys that you are going to make that wire transfer into their account. And that's initials there at the bottom. And we're on 20. So, entire agreement changes. This agreement constitutes the entire agreement between the seller and the firm, and there are no representation, inducements, or other provisions other than those expressed herein. This agreement may be signed in multiple originals or counterparts, all of which together constitutes one and the same instrument. All changes, additions, or deletions to this agreement must be in writing and signed by both seller and firm. And here to note, the North Carolina Real Estate Commission publishes a series of question and answer brochures and address common questions on a variety of topics relating to the real estate transactions, including offers and acceptance, earnest money deposits, home inspections, and real estate closings. They are available for free of charge on the Commission website at www.ncrec.gov. So this is for your information and for your awareness. If you wanted to go to that site and look up any information about these specific topics, you are more than welcome. And this states that the seller and firm each acknowledges receipt of a signed copy of this agreement. So we got signatures, you all, here. Let's see what this says before the signature. The North Carolina Association of Realtors makes no representation as to the legal validity or adequacy of any provision of this form in the specific in any specific transaction. So the North Carolina Association of Realtors, they don't make any representation. They can't give you any legal advice on these contracts and agreements. You have to consult an attorney. And this is where the sellers you assign. And we would need all your information here, contact information, or if you're a seller in your entity, we would need that information that will go in this area. And then I would put my information in this bottom half. Yep, and there you have it. 13 pages of the exclusive right to sell. If you all have any questions or concerns, please don't hesitate to reach out.